in my motion, one of the statements I made was that Mr. Miller false statements resulted in Judge Brady's removal, that he continues to willfully knowingly lie to the court officials. I have earlier on provided evidence of the emails that were willfully and knowingly sent to me, Ms. Davis, and everybody in the courthouse. I subpoenaed Ms. Harzock because she is, first of all, Mr. Miller is obviously the recipient of, sender of those emails, so that's why he was subpoenaed. But also Ms. Harzock was subpoenaed because she's a public official. I do have public records request emails where Mr. Miller did receive an email from Ms. Harzock where she actually, let me tell you this.
Do you have copies for counsel?
Yes, yes, I do, Your Honor. Yes, I do, Your Honor. Let me see. Okay, so that's going to be Exhibit 6.
Hold on just a moment, give them an opportunity to review it.
Yes, Your Honor. Yes.
Judge, I already have an Exhibit 6.
Exhibit 7, I am very sorry. Yes.
Hold on. Let counsel review it first.
Yes.
Any objection?
I'm sorry, Your Honor, objection to it being entered into evidence?
Yes.
Oh, no objection, Your Honor, thank you.
All right, so you'll hand it to,
So,
copy
Chris?
to the bailiff.
So on January 8th, 2019 at 9:44 a.m., Ms. Harzock, without informing me, sent email to Mr. Miller and Ms. Worthington stating, Judge Teague does not need your written facts. He got a copy of the CD. Do you want to take a look at the order before it is filed and mailed out? Then my public records request also revealed an email that Ms. Harzock sent to Judge Teague where she says email from Jeff or, so let me just proceed one at a time. That's going to be exhibit to the Constitution. And counsel can review this if they'd like to.
Any objection?
Object.
No, Your Honor.
All right, sir.
Thank you. So there's another email from Ms. Harzog to Judge Teague. I understand this is the official email address from Judge Teague, where he has on nccourse.org. And she says, email from Jeff on Grodner. And this is forwarded below. There is a forwarded email messages, which says Jeff Miller, mail to jeff@miller@audino.com. This is from, and then it says to megan.l.harzog@nc.org, nccourts.org. I do not have that original email. I have to admit, public records requests that I've made twice have revealed that it doesn't exist. It is my contention that Ms. Harzog, as part of my public records request to her, she did delete it intentionally to conceal that information.
You have any
Because
evidence to support that?
I don't. This is why I wanted to ask her. This is exactly why I wanted to have her testify. Because there is an email that I know exists, and she was the only one that could have deleted this. But basically in that email...
Can you substantiate that claim, sir?
I can only
I'm
say...
just asking you, can you substantiate that claim?
I can substantiate it by the fact that I've made 2 public records requests.
No, my question is, simply because you made the request does not substantiate the claim that Ms. Hartstall deleted it. Those are serious allegations.
Yes, Your Honor.
I don't know her. I don't know anything about her. I wouldn't know if she walked in the courtroom right now.
Yes, Your Honor.
But those are just serious allegations. That's why I asked you if you had any evidence, not statements, but evidence.
The evidence is that when I asked her for public records request, Ms. Harzog did not send me those emails, meaning that she was deceitful to me the moment she was
No, sir, that's not
responsible.
what you said. Your statement was that she deleted the email. That's why I was asking you, do you have any evidence to substantiate your claim?
Your Honor, my statement was my contention is I don't have a proof that she did that.
Okay. Go ahead.
So, given that that email has been received by Ms. Harzog, it says, no, this is from Mr. Miller to Ms. Harzog, no, if he does not need me to prepare a proposed order and does not need me to submit any proposed findings, and I would copy Grodner even though he defaulted and did not appear, then I think the best thing to do is simply send it to us in the normal course. Thanks, Megan.
All right. Now, as it relates, was there a request for interrogatories?
There was a request for interrogatories.
And was there a motion to quash that request?
There is, Your Honor.
All right. Now, the motion to quash the interrogatories is allowed pursuant to Rule 26. Rule 1A, Rule 26. Now, as relates to your request for a new trial, or your request for a continuance, rather, what does Ms. Hartstock have to do with your request for continuance? Or is this in conjunction with your request?
All right, let me go back and say, in my request for continuance, I said that Mr. Miller continues to willfully and knowingly lie to court officials, and the court accepts Mr. Miller lies as the truth. Mr. Miller, just today, told you he stands by every single email that he sent, that I recited, that he did not have any communication with Ms. Harzog. This is your proof that he was lying to you right now. And it is my understanding that Your Honor is willing to believe his lies and proceed with this hearing, even though...
Listen, where'd you get that perception?
This is my contention that...
Well, it sounds like that's your contention of the whole system, sir.
No.
Then why did you say that? Because you have no basis for making that statement at all. I'm simply asking you questions, and if you don't answer them according to what the law requires, that doesn't imply anything. I'm just asking you to provide to this court what is sufficient in your case. That's all I'm asking. I don't know anybody here. I don't have a dog in this fight. I know nobody. I don't know any of these attorneys. They just introduced themselves along with you. I don't know these people. So I'm here to make a decision based on what the facts are, what the law is. I don't do any preferential treatment.
So, okay.
So that's an assumption that you have taken that's not accurate. And I just wanted the record to reflect that. Go ahead, sir.
So I like to state that I have proven beyond any doubt that Mr. Miller has lied in the emails that he sent me to Ms. Davis and Ms. Harzak. Ms. Harzak also has been dishonest to me, and my position is she didn't do it, I believe, to deceive me. I believe that she has done it upon urging from Mr. Miller, because some of these emails that he sent immediately, he almost suggested what Ms. Harzak is supposed to do. He was writing that he told her, kind of implying that maybe she should not tell her that, to me, that she had any emails. And in fact, later on, when she responded to my public records request, she did not provide me those emails. I have made this public records request, and those emails showed up, and Ms. Harzak has not provided it. That's why I wanted to ask her to testify, to basically be a witness and an evidence of Mr. Miller lying.
Well,
May I be here briefly? Your Honor, public records requests need to be made through AOC, through Jonathan Harris, our general counsel. It is impossible to delete an email. AOC is always going to have retained those emails. And so if those records, public records requests are made of AOC, AOC will comply with the law.
Mr. Grodman?
Yes, Your Honor.
In response to counsel's statement.
Yes, perfect. I mean, it's a wonderful segue. So,
Excuse me,
yes.
that didn't answer the court's question, sir. Counsel indicated that if you'd like to get public records from any state agency, that you would contact the Office of the Administrative Courts.
I did, yes, Your Honor. And this is the proof. This is, we can put it as Exhibit 9. On January 12, 2019 at 7:07 a.m., I have made such requests. And if you could pass it.
The point is, it is improper to send these requests to individuals throughout the court system. They need to go through our general counsel, John Harris.
Okay. Let me,
Judge, I know that I received an email, and I thought it was from Ms. Davis, that told him how to make a public records request as well when he started down this road.
Now, hold on, Mr. Grodman. Sir?
yes.
I know this may sound harsh, but I'm not here for a fishing expedition. I'm here to hear some motions. Your motion to continue is that you think Mr. Miller is being false to the court and that he shouldn't be involved in the case.
Yes, Your Honor.
Well, other than what you've alleged that Ms. Hartsdog would say, and if she would say that she's given you these emails, what bearing has that got to on the issues of this case?
Well, one is obvious, Your Honor. Mr. Miller lied to Your Honor just a few minutes ago. And Your Honor did not stop him, didn't say, please, Mr. Miller, tell the truth. And Your Honor didn't try to verify whether he was telling the truth.
Excuse me, I'm not here to try a case, sir. That's not my job. I'm not here to assist in a case. I only asked for clarification.
Yes.
So whatever assumptions you want to make, that's on you, but the record is clear. I'm not here for preference. I'm not here to assist. I'm trying to get to the bottom of this